Republican Reps. Jim Jordan of Ohio, and James Comer of Kentucky, threatened to hold Attorney General Merrick Garland in contempt of Congress if he doesn't provide them with materials they requested related to Special Counsel Robert Hur's investigation into President Joe Biden. But history shows such a threat is hard to prosecute. In order to hold Garland in contempt, Jordan and Comer would need to take a resolution naming Garland and charging him with contempt of Congress through a committee vote, and then it would have to pass the House. But, it's rare for criminal contempt of Congress to result in prosecution, according to the American Bar Association, as a citation would be sent to the U.S. Attorney's Office, which doesn't have a legal obligation to pursue the charge. In 2012, the House used this method and sought enforcement in district court against President Barack Obama's Attorney General, Eric Holder, for not providing documents related to an investigation into a gun sting. However, that case took 7 years and before it resulted in a settlement, according to the ABA. So, while Garland could be held in contempt, if recent examples, including Holder, former Attorney General William Barr and former White House counsel Harriet Miers, are any indication, he would likely not face any consequence. If Garland doesn't produce the materials by April 8, the committees will consider taking further action, including holding him in contempt of Congress proceedings. The Justice Department made public 2 redacted transcripts of Hur's interviews with Biden, which revealed Biden did forget key dates, but that Hur gave mixed accounts of the president's memory. Earlier this month, just before Hur was scheduled to testify before the House Judiciary Committee about his report, the report found Biden did willfully retain classified documents, but did not recommend charges out of concern that it would be hard to convince a jury of wrongdoing, as Biden could portray himself as an elderly man with a poor memory. Hur has defended his report, saying he had to assess the president's state of mind in order to determine whether he retained the documents willfully, and that the evidence and the president himself put his memory squarely at issue.